We're on the record in the Jimenez matter. Case number D507566. Your appearances, please.
Good morning, Your Honor. Val Fuji, bar number 5955, on behalf of the plaintiff, Angela Jimenez, who is present along with family for support.
Thank you.
Attorney Don Lozano, and I have Lupe with me at my table, as well as Catherine Hughes, and my bar number is 3475.
Thank you. This is the time set for an evidentiary hearing regarding support obligations and order to show cause. Counsel ready to proceed?
Yes, Your Honor.
Okay. I have one set of exhibits. Do you have any exhibits?
No exhibits to offer, Your Honor.
Okay. All right. Very good. All right.
And Your Honor, we were just given a copy of the pretrial. I was told Ms. Fuji was withdrawing. I didn't even see this until 2 seconds ago on this pretrial memo, just so you know. I was not served with it. And then for the record, Ms. Fuji was supposed to file something for an order to show cause, and nothing was filed, and it was deficient. When Mr. Jimenez did that, a matter was taken off calendar. This was then put on calendar, and it was not corrected. So I'm wondering why we're going forward on an order to show cause when in your own order it shows that her order was deficient. I'm asking just for the record because I need a record, Judge. And then you chose to go forward on an order to show cause when her order to show cause was deficient pursuant to your order. But you didn't do that for Mr. Jimenez. You overlooked his deficiencies. You didn't overlook his deficiencies, but you overlooked Ms. Fuji's, and she's a lawyer.
And then
I'm asking why. I'm asking why, Judge, for the record. Because I don't believe that we're going forward on that because we actually had that matter paid off immediately, and that's part of the record as well.
And Your Honor, I believe the pretrial memo was filed last Thursday, e-cert to Ms. Lozano, who received a copy of it. Substantively, it was a recount of the events that had taken place thus far. Logistically, there's no prejudice because there are no additional witnesses and no new evidence listed as exhibits to that pretrial memo. As far as her allegation regarding a deficiency to the order to show cause, the court recalls I had filed 2 previous orders to show cause. Back when it was deficient, it was failure to file an affidavit with more detail indicating which part of the orders we were seeking to compel. The court then rectified that at the subsequent hearing on May 16th, 2018 in your order when you said we are going forward on the order to show cause why the defendant should not be held in contempt of court, specifically for the bonus that he was ordered to pay 100% of, and by his own admission in the court minutes, court's indulgence, he failed to pay. So those are the language of the court.
Which was corrected after the last court hearing, but her deficiencies weren't. I'm asking specifically as to that issue. Mr. Jimenez filed a notice to change this in November, right after the hearing. It would have stopped all this bleeding back then, Judge. You said no because it wasn't procedurally proper. I agree. Ms. Fuji, an attorney then, was told by this court to follow up on an order of show cause. Did not do it, didn't correct the deficiency. But the court thought it was a good idea to correct the deficiency for Ms. Fuji per what she just said, and I don't believe that that's proper under an order to show cause. It has to be done properly by the litigant, bringing the proper affidavit, which was not done. The court cannot correct an affidavit for a party. So I believe when you're saying we're going forward on an order to show cause, there is no reason sufficient to go forward on an order to show cause because it was not done properly. It's in your order that it's deficient.
And Your Honor, I'm referring, I pulled the minutes specifically regarding this issue and the case where the court found deficiency, which was subsequently rectified by this court when it took testimony and the defendant was admonished for not giving 100% of his bonus that was previously ordered and reduced to judgment.
My recollection was that he made the admission in court.
That's correct, Your Honor.
And that was the reason.
And that is correct.
The order to show cause.
That's correct.
And what I'm saying is her deficiency was overlooked where his was not, when this could have been corrected because his income was not $98,000 like she represented at trial. It was $78,000, but he was improper person. Okay? So that's why we have this incredible judgment like this, and you're thinking that he's not paying or taking care of his family. They made the same income. She actually got a college degree while they were married. He helped pay for it to
Are you
finish it off.
arguing your case now?
No, you're wrong.
Because-
I'm saying they're going backwards on a matter that we will have to go backwards on because of the income. Okay? And what I'm saying on the order to show cause, there was no proper order to show cause that was issued. Because again, what he admitted to was, did you get the bonus? I got a part of it. Smith's was not properly served by Ms. Fuji's office with the order. He took what he was given as soon as he found out when we were here in court that he got a part of it still. Okay? He immediately paid it back, and he said that in court as well. Okay, that we were going to take care of it. His family, right as we left, got the money orders, and she got it within 24 hours in her office.
Your Honor,
So why we're in an order to show cause on that matter is a waste of the court's time, and she needs to tell you that she got that within 24 hours.
And Your Honor, just to make the record clear, this court has an excellent record in this matter regarding the notice and entry of the order for the wage and bonus assignment, which was filed on February 14th, 2017, and the notice and order to show cause filed on July 6, 2018, where Guadalupe is directed to appear before the court on today's date to show cause why he has failed to pay, specifically all future bonuses, in accordance with EDCR 7.21. He stated in court, he spent it, in addition, that he received the 50% and he was ordered to then provide it to my client, and Ms. Lozano was ordered to see why Kroger is ignoring the orders of this court.
And that's because Ms. Fuji didn't serve him with the order. Right there.
We're prepared to go for, I believe that's an allegation that's unwarranted, but
she said that Kroger didn't get the order in court. You want to go ahead and say what she said? She didn't get it. They didn't serve him. And a pro per didn't know what to do, but a lawyer knew what to do.
Why is this not in your brief?
Your Honor, again, if I was told that she was withdrawing, there was not even a pleading, not even a document that's showing that they were going forward today. Okay, so again, I thought we had a motion to withdraw because we had that. We were talking to your clerk on Friday.
Yeah, it's set in September.
I understand that. I
And
understand
wouldn't
that.
issue an order.
And then we have
shortly
no
following.
documents going forward. Nothing has been complied with on the pretrial order. I didn't even think we were going forward today. We're here. Again, I did not even know that she had hired attorney again because she was withdrawing.
Judge, so for the court's edification, which really proves that she does get e-served the filings in this matter, I had moved to withdraw. I had moved to withdraw before an order reducing my attorney fees to judgment for Ms. Jimenez in excess of $15,000, for Lupe for $7,000, neither of which were being paid or ordered. I filed a motion to withdraw. It was denied. Therefore, I'm prepared to go forward today, Your Honor. And if counsel's done with her I guess it's pre-hearing argument, I'd like to make a brief opening statement.
Well, it's my understanding that he's purged any contempt.
Absolutely, Your Honor, and she knew that before coming in here today. I'm just saying, I want us to use the court's time for what you said we were supposed to do, which is he willfully underemployed?
No, the
No,
attorney...
there's no time. There's nothing that's been showing that from the beginning of time.
Judge, if I may, the only thing that's reserved is my attorney fees. He made an admission in open court. Regardless if Ms. Lozano believes Kroger didn't get the order, regardless what her belief might be, Mr. Jimenez knew. And this court admonished him not once but several times about this bonus. And he admitted in open court that he received it, and that not until we brought it up was he then truthful about it and was ordered to then provide in accordance with the order to my client.
And the order was never served on Kroger by counsel.
Is the water good? Is the water good?
It was your opening.
Yes, Your Honor. Just to make it brief. Thank you. Court's indulgence. Okay. NRS 125-1507, subsection 7, allows modification of alimony and or child support based upon a, quote, changed circumstance. NRS 125-150-12 allows a review if there's a 20% change. However, that review does not entitle Lupe to retroactive relief. This court stated it in its May 18th, 2018, or May 16th, 2018 order. And I will state it again, notwithstanding the pretrial memorandum confusingly filed by the defendant in this matter. The decree or agreement is not subject to modification by the court as to accrued payments. Colati versus Colati, there's numerous cases on this, judge, that go back in the 90s. Nevada law clearly prohibits retroactive modification of a support order. Payments once accrued for either alimony or support of a child become vested rights. These are rights that parties count on. These are rights that parties look forward to, a budget based upon, and therefore they cannot be modified or voided. Now, if counsel needed edification, Shriver case, 1992, explained what accrued payments are for purposes of modification under NRS 125-150 subsection 7. You don't get retroactive credit while you're in arrears. All right? Keep this in mind, Judge, because as we sit here today, even though we haven't had an evidentiary hearing, it is my client whose alimony of $900 a month for the next 72 months plus $1,100 for the next 36, it was her support that was suspended. Lupe, as of June 1st, the court, before this evidentiary hearing, suspended the alimony payments. So it is going to be my client who, for 4 months, an additional $3,600 that will be seeking here today. Now, the Meniere case. Judge, where evidence of willful underemployment preponderates, presumption will arise that such underemployment is for the purpose of avoiding support. The burden of proving willful underemployment for reasons other than avoiding a support obligation will then shift to the supporting parent. Further, willful underemployment is always a factor for the court to consider in setting alimony and for modifications of the same. I'm citing Rosenblum and I'm citing Rodriguez. In this case, Judge, we have one better. You reduce things to judgment. This court entered orders. The defendant failed to follow those orders. Those orders then were subsequently reduced to judgment. By law, under Rule 60, him and his counsel would have 60 days to set it aside, or at least, under Rule 59, file a motion for reconsideration within 10 days. That was not done. I appreciate that not 3 years later, not until we finally got garnishment, finally, did he then hire Ms. Lozano to take a second bite at the apple. If I may read from the court's order after May 16th. There is no evidence to support why he is demoted. He suffered a demotion. The court did not find him credible in his first motion. There were no viewed, any demotion, or any evidence to justify his complete disregard of the orders. Now on this second motion, the facts are no different. He has appeared to neglect his job duties. There is no evidence to determine the cause of defendant's failure to perform at a level he was capable of in the past. Defendant certainly demonstrated a lack of desire to support his family during the pendency of this divorce, even misrepresenting his income and falling behind on his support obligations from the very beginning. This is page 3 and 4 from the May 16th or 26th, 2018 order. Your Honor, you are going to hear no evidence in this case. This could be an evidentiary hearing that would be done by legal briefing only. I tell you this because the mere fact he now says he doesn't make the money he used to make is not enough to prove he's not willfully underemployed. Giving us a 1040 without attachments, with no W-2s, or one paycheck stub isn't going to cut it in this case. Ellis Carucci allows this court to review credibility of the party, and that will not be disturbed on appeal because you get to see these parties over and over again. As attorneys, as judges, our job involves a lot of mental forethought. We have to be prepared and we have to think on our feet. Your Honor, the evidence in this case will show that Lupe Jimenez was demoted because he failed to walk the floor daily, and he failed to hold meetings with his staff. There will be no documentation to explain that he somehow was unable to walk, or that he lost his voice or suffered from late laryngitis, nor will you hear from a medical expert that he suffered from depression or mental illness, or he sought treatment or took medication for some reason, physical, mental, or otherwise, that affected his ability to earn the same money he did for so many years. Case law, should this court require additional briefing, our more recent appellate court cases show if you have a history of misleading the court, failing to cooperate, failing to follow orders, this court can conclude that any request to modify his child support or alimony obligation is good enough, without having to do a detailed analysis, which would not be disturbed on appeal. In addition, Your Honor, fees is something that is still outstanding. That's reserved for the plaintiff and not the defendant. NRS 125.150 subsection 3 provides that you may award reasonable attorney fees in a divorce proceeding. Also, NRS 125.180 subsection 1 may also award attorney fees associated with obtaining a judgment for support arrears. However, the only excuse why he hasn't paid his fees that he was supposed to pay before 3 years ago, and that was to me of $8,000, would be for a hardship under NRS 125B.1402 subsection C. However, he has made no allegation or claim for the same. When we go through Judge today, it's easier because there are judgments. Judgments that you can see even in the Register of Actions that were filed in 2017, refiled for judgments in 2018, all of which he has failed to set aside. So keep in mind when they try and do these funny numbers, if he had 6 months, he cannot change those already reduced to judgment. Now we talk about those that are accruing. I think you'll hear evidence that the defendant would like to somehow retroactively go back to October 2017 because he filed something. Your Honor, once a determination is made and an amount is reduced, those amounts are accrued and earned. If it has already passed October 2017, those are accrued and thus cannot, in no way, shape, or form, under the court statute, which you so aptly stated in your order of May 2018, and I have reiterated this morning in the case Colati, is a vested right and cannot be altered. It's unfortunate we have to go forward today. I feel like we keep recreating the rule. What always happens, though, however, is that things keep accruing. The evidence in this case will show under Jackson, insofar his expenses are affected by cohabitant contributions and his roommates with his family members, we can, in fact, increase it. The fact that hers has been suspended. It took 3 years, Judge, to get this, and the evidence will show. One other thing. That waiting so long cannot give the defendant an unfair advantage. The court's indulgence. What's the bankruptcy case? Not Allen. Saragusa, yeah, Your Honor. Saragusa was a case where the guy tried to pay alimony up front super early and said the period had expired. Therefore, the wife couldn't go back in and get additional alimony. And the court said you can't do that. You can't pay early to try and avoid your obligation or to prevent her from coming in to file for more alimony. Following that same vein, you can't wait to pay. You can't wait 3 years to pay. You can't wait 3 years to pay and then say, I want to go retroactively back. And that's what Saragusa says. A supporting spouse cannot deprive the court by jurisdiction by failing to make alimony payments. And that's further reiterized by Brown. In this case, imputed income, and there's a series of cases, when someone's not making their actual earning capacity. There was a case where a gentleman relocated to Australia, got another job. The court did not modify, and it was not disturbed on appeal because he didn't explain any reason why he wasn't making the lateral position, even though he went out of the country and had to relocate. He didn't show any job searches, any attempts for movement laterally, any phone calls made. In this case, Your Honor, you're going to see evidence from 2016, a record of a demotion, a one-page sheet that with nothing more, without any explanation, is not going to be sufficient to sustain a request. Thank you.
Okay, Your Honor, you already know the background, but we had a party that we were divorced over 3 days. okay? And then you took the matters under submission so that even though we had 3 days, January 26th, February 10th, and March 21st for the trials, we had the decree entered the 26th of May, but all the financial issues weren't done until, let's see, October 25th of 2016. Immediately, he filed a motion saying, look, I need to do something about this. You found it to be deficient. He didn't get it. He didn't take care of it. He had to get money together to hire an attorney. We filed it in September of 2017. It's not 3 years, so I don't know the math we're doing on 3 years. Hasn't been 3 years. Okay? I did it less than a year after you entered the financial information. Okay, after that. How we got here, Judge, you have to understand, it was a crazy order that was never stopped by prior counsel. He had Kurt Smith on there before. She moved out of the residence. He stayed in the residence. She needed money to leave. No one stopped the bleeding. They made the same money, okay? What was interesting is I had him even pull the Social Security records, okay? And it's all the way through. They're making about 50, 60, 50, 60,
Please don't
70,
refer.
50, 60.
Okay, please don't refer to documents
I
that
know,
are
this
not
is
in
even,
evidence.
And it's not going to be. It's only going to be referenced. This is not something that's in the evidence that we've even put in our book, Judge. We have it, okay?
I don't want
Well,
you
then
to
if the
refer
evidence
is
to
gonna
object-
documents in your opening statement.
And it is an opening statement, Your Honor, absolutely, okay? But it'll show through his testimony. I just picked it up because I don't know his testimony. But his testimony, it'll show what they make, 50, 60, 50, 60, 50, 60. She made the same money. And she actually got a degree during their marriage, okay? He'll ask to testify as to what was happening because he started working for Smith's for $3.80 an hour as a beggar, okay?
Ms. Lozano,
Yes.
this is all pre-decree.
And I understand.
I'm not going to revisit.
I understand,
Sounds
Your Honor.
pre-decree.
I understand that, and we're not arguing that. And you have a pre-trial.
But you
that
are
says,
arguing pre-decree, so please
No,
go
Your Honor.
post-decree.
again. She was saying 3 years, and it wasn't 3 years, and no one was stopping her. What I'm saying is, this is what happened in this case. They were making the same money. We have a judgment that got out of control. She's saying we never should have ever changed it because it became an order by this court. You know that life is fluid, okay? We know that none of the orders say if you can't pay it because you truly can't pay it and it's in good faith, okay, then you can come to this court. That's why we have statute on point. That's why we have case law on point that she's referring to. And Miriam Rosenberg, guess what they did? Huge jobs down to nothing. Neurosurgeon down to $1,200 a month. No. Or if you're making twice as much in another jurisdiction moving to Nevada, you should be making more. But that's what happened in Rosenberg. No, that's not what happened. What happened in this case was Smith's. He's been working there for 25 years. Okay, started as a bagger, got all the way through. And that's what I'm talking to you about right now. Nothing pre-decree. He's been doing this 25 years. He's not going to quit because someone had a problem with him because of a corporate changeover. What happened at the time of the divorce?
And you're, I'm just
Grover
going
and
to...
Smith, what happened? This is going to be in testimony. Again, I didn't stop her in her opening either when she was misquoting even how long it was been since it had been in front of this court.
Your Honor, if,
I'd appreciate the same. I'm almost done, and we can finish.
Hold on. What is your objection?
Your Honor, and she misstates the record because the motion that he filed was with counsel and there was an argument and the court heard that argument and reaffirmed its order. She made it sound like there was no argument, that he didn't get it on because service was improper. That's correct, but then he did it with a lawyer and we had a hearing, and at that hearing he presented his own testimony and they lost that motion. So I just wanted to quote that. But I will be making an objection. If she filed it within a year, I don't care if she filed it within, 7 months. If it's beyond 6 months under Rule 60, they didn't set it aside for mistake, for neglect, for error of law by this court. They cannot speak to it. So in order to expedite today's hearing, it should be focused on what the court asked us to do in its May 2018 order, and that should be why. And what relief he's asking going forward as to child support and alimony, I presume, because the other things are judgments.
Thank you. Go ahead.
Yes, Your Honor. But if we don't show how we got here, then you don't understand how big this thing got, which out of control. When they're making about the same income, for them to have an outrageous spousal support award is incredible. In his wages, She went back 3 years.
Yeah.
Okay, and the wages, it showed one bonus of $118, one bonus of $100,000, one time. And you use that to go ahead and calculate spousal support. That's why we're here. It's not a judge set aside the order. I already put it in my pretrial. Those orders, those judgments stand, and I already said that in my motion. I've never asked for anything different since September 29th, 2017, and it hasn't changed. What you thought was going to happen was a new position was going to open. No, he is no longer
She's
the manager.
arguing the case, Your Honor. I'd like
Your Honor,
her testimony.
I am
on
arguing
it.
what he will be saying on the stand.
Okay.
And that's what an opening statement is for.
All right, you don't need
Okay.
to be so loud,
Okay.
please.
So, he will tell you about what happened with the corporate changeovers. Everything's changed in the structures of Smith's. Okay, Kroger, Smith's, all the things that happened. They're trying to stay ahead of Amazon and Target, all the people that are trying to do groceries. They're trying, and they're doing a lot of things that keep innovative to stay ahead of the curve. He believes in Smith's. He believes he will be able to get back up, but they've changed the structures. There is no longer manager and assistant, which has a certain salary amount. No, now it's manager and 3 assistants, which dilutes the salary. Okay, he's one of 3 assistants. So again, to get back up there is going to take a lot. She went to college and finished college during the marriage. He couldn't afford it because he was helping her get through and continue to raise the children. Guess what? He didn't go to college. They're now passing him over for people that went to college. Okay, that's at the same time. So he's going to have to testify as to what happened in that time and where we're at right now. He's trying, and he's still with the company that he believes in, that he's worked with since his only job. He's been there since he was a bagger, $3.80 an hour. They met 2 years later. They were married 2 years later. Okay, so they came up together making. There was no big disparity in income. There was no need for ability to pay. I'm saying that's what got us here, Judge. Now we have these judgments that he's having to pay. He'd love to pay the prior judgments. He wants to pay the prior judgments. He just can't afford the stuff going forward. With the stuff going forward gone and the proper child support being calculated by this court, he'll be able to take care of it very quickly, including Miss Fuji's fee, okay, all of which we've acknowledged, Judge. Okay?
Thank you.
All right. Your Honor, at this time I'd like to call Lupe Jimenez to the stand.
Thank you, sir. Appreciate it.
Will you please raise your right hand? You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated.
Your Honor, for purposes of this case and to expedite, I'm going to ask to treat Mr. Jimenez as an adverse witness.
That's fine.
Okay.
Thank you. Lupe, you're here today asking for relief from this court for future child support. Is that correct?
Yes, that's correct.
Okay.
To be able to cater to our children to make sure that their father can take care of them, yes.
Okay. And where are you living right now?
I'm living with my brother currently.
Is that where you were living on or around, December 2016? Same place?
No, that is incorrect. I was living in somewhere else
Where were you living at that time?
at 9884 Cohabitant.
Who was living with you then?
My brother was,
Okay. So you were living in a different place, but you were still living with your brother?
yes. But at that time, that was something that I was renting, and they were saving money to buy a home for them and their 4 children. I was only paying $5 more a month than Angela was, and the house was big enough, so I let him stay there. Yes,
Okay. And now you live with your brother
that's correct.
and your brother's family.
That is correct.
And how big is his family?
They have 4 kids.
Okay. And the place you stay at, are you renting?
Yes.
Is your brother on the lease, or are you?
No, my brother is He's the owner. Him and his wife are the owners.
And so you're renting from your brother, and he actually charges you rent?
That is correct.
How much does he charge you?
$500 a month.
That is less than you were paying on or around the days of this divorce in January and February 2016. Do you know that?
That was less than I was paying. Say that again?
At the time of the trial in this matter, which was January, February, and March 2016, you were paying more. Do you recall that?
Yes.
So now you're paying less. Let me ask this. The reason for your request to pay less child support, isn't that you're saying because you were demoted at your job?
That's partially, obviously, the income has something to do with it. Yes, I was demoted at my job, and I have less income now, so.
Well, you say you have less income, but we know already that you have more additional funds in which to pay because you pay less rent. Is that correct?
That is incorrect, because I still have to fluctuate all the bills that I have and provide for my kids, our kids, to make sure that they have the clothing,
Yeah.
school, and lunches, and in between that.
Okay, so let's talk about that. You said it. You say in your financial disclosure form that you pay $200 a month for your children's clothing. Is that correct?
Yes.
Would it surprise you that Angela's never seen any of these clothing that you've bought for the kids?
I don't know what she's seen, so you guys have never seen anything that I've done, but I do it.
Okay. And as you sit here today, you still aren't paid up on your child support arrears, are you?
Objection, Your Honor, the record shows that different.
I don't know what kind of objection that is.
Objection, the record, cause for a legal conclusion.
He knows. Isn't it true you aren't paid up in your child support?
Same objection, Your Honor.
It's a question he can answer. You can, don't look at your counsel, you have to answer me.
Oh, I believe that's paid up. You guys garnish all the wages, so I don't have a detailed format of it. I believe that's paid up.
But you don't know for sure.
I don't see how it's not paid up.
Okay. But you don't know for sure.
It should be. I don't know for sure the details because I don't have a statement in front of me that says how much I've paid or haven't paid. But if the child support arrears should already been paid off a long time ago, because the only thing that hasn't been paid was the alimony. Okay.
Well, you say the alimony. Isn't it true you're supposed to pay $500 towards the equalization payment of $29,000 per month? Wasn't that the court order?
Don't I pay it don't I pay that?
Again, objection. Ask for legal conclusion. He's getting the garnishment done.
Your Honor, I'd ask that counsel make a proper objection.
Objection calls for legal conclusion.
Okay. Here it is. It's over your note. Were you aware that you were supposed to were you ordered to make $500 towards the equalization of payment arrears, and you've made none?
Objection. We've had the
It's a fair
garnishment.
question.
She knows that they're being garnished. She absolutely knows because she's gotten almost $20,000. So she does know it's getting garnished.
Your Honor, if I can ask questions, she has an opportunity to redirect questions, show items otherwise, but I can't have counsel testifying. Your Honor, there is ample evidence in this case prior to today, and judgments that have been filed. Schedules of arrears. If there is something otherwise, I'm sure counsel will, and Lupe will give it to us, so we'll know.
Okay.
So,
Your Honor,
again,
objection, Your Honor. We have no schedule of arrearage that has been filed in this case. There are supposed to be things filed in this matter. You had a pretrial that said file things and have things done. Can you tell me for the record, is there a schedule of arrearages that's been filed? I have none.
All right, Your Honor, counsel.
Your objection was calls for a legal conclusion. I overruled it.
And then I asked, was there a leak? Because she's referring to a schedule of arrears that, again, I haven't been served with anything. So I want to make sure, for the record, is there a schedule of arrears that you have, Your Honor?
I can't, if counsel doesn't have the ability to read the register of actions, to read the schedule of arrears that were previously filed, and the subsequent updated schedule of arrears that were filed the first time he tried to do that, up until June 2000, if the court recalls.
So nothing's been filed since the
Yes,
garnishment, Your Honor?
You know, if I may, if the court recalls, you had both of us. You sent both of us to do briefs. after June, well, right after the first time we came in March 2018, and we did. We filed, and we did schedule of arrears on every single thing that were filed. If counsel doesn't have access to the Register of Actions, doesn't know the pleadings, doesn't know the procedural history, I can't be interrupted. What I don't want is to go beyond my scope of direct, because I'm trying to keep it narrowly tailed so we can get this done
And
very
Your
quickly.
Honor, she can't ignore that they've been getting money, ridiculous amount of money.
You have an opportunity to cross-examine.
She's ignoring the fact that they're getting.
We are not getting
Stop.
zero
Stop.
on the equalization.
Stop. Your objection was overruled.
Thank you.
Continue your examination. You have a chance to cross-examine. And yes, there are schedule of arrearages as of May 2018 that are filed in
I
this
know, I
case
know.
to answer your question.
Were you aware you were ordered to pay $500 a month towards that $29,000 equalization payment?
On top of the garnishment?
Yes.
No.
Were you aware you were ordered to pay gymnastics, past gymnastics expenses of $19,000 for Ivy? And that also is not being garnished.
Objection misstates the record, Your Honor. There's no $19,000.
There's no record about a garnishment, so I don't know.
So I said absent a
I have to overrule
garnishment.
your objection because the garnishment is not in evidence. Go ahead and answer the question.
Ask the question again, please.
Were you aware there's a judgment against you for Ivy's past gymnastic expenses of approximately $19,000 that's not being garnished?
I know there's a judgment, and I don't have the funds to pay those
Okay.
extras, so you guys are garnishing my wages, and I'm to my limit.
Okay.
Yes.
So let's talk about that. So as you sit here today, have you paid anything on your own volition without it having to be garnished from your paycheck?
I have no more income that allows me to do that. Half my wages are gone. I have to be able to provide for my kids food, clothing, outings, whatever it may be. That's what I need to do. Before I pay any other thing, I have to take care of them.
So the equalization payment of $29,288.40, for which you were ordered $500 a month in arrears, you have not paid anything for, correct? It's a yes or no.
Well, I've been getting garnished. How can I pay it?
If I were to tell you the garnishment,
Objection, Your
Can I
Honor,
pay it?
calls for a legal conclusion. She doesn't know
If
where
I-
the garnishment is going.
if I can get my question out.
Overruled.
The garnishment is coming from the district attorney's office, not from me personally, Valerie Fuji. You understand
Well,
that?
the court or wherever it's going, I'm still having to put that money out.
Are you aware it's coming from the DA's office, yes or no?
I do.
Okay. Are you aware the DA is not garnishing the equalization payment that was reduced to judgment, for which you were to pay $500 in arrears?
Objection calls for a legal conclusion. Objection calls for speculation as to what the DA's office is doing or not.
He already answered it. He said yes. So, the gymnastics that was reduced to judgment, you haven't made any payments on that. That's not included. The equalization payment, you've made no payments on that. And my fees of $7,000, you've made no payments of that, correct? You understand that's not being garnished from the DA's office?
Objection calls for a legal conclusion, Your Honor.
He's
He doesn't
allowed
know
to-
what the garnishment's on. He said, asked and answered. He said that several times. He doesn't know what monies are being garnished through his wage assignment. He knows half of his income is gone.
That's true.
You don't know what you're being garnished for?
No, I just know that they're taking the money. That's all I know.
Let's go back. You're saying the reason you can't pay the money now, the past items reduced to judgment, anything going forward, because you make half the money you used to make, correct?
Say
Right.
that again?
You're saying you can't make these payments now that were reduced to judgment and going forward because you're making half the money you used to make, correct?
Well, it was difficult then.
It's a yes or no.
Well, it's not a yes or no. It was difficult then, and it's difficult now.
Isn't it true, even when you made the money, you never made the payments?
We got to remember, I was renting a place for $1,600. I can't afford the $1,600 anymore, so I'm paying $500. So I don't have the funds.
So that frees up $1,100 for you to start paying towards his $70,000 of arrearages.
I don't live in $1,600 home because I don't have the funds. If I did, I would live there because my kids need this. They need the space. They want their own place.
So clearly you brought your expenses down because you're making a lot less, right?
No, because I can't afford anything. That's why.
Well, we know you're making about, according to your own testimony today, from $1,600 to $500 in rent, right? Mm-hmm. Okay, is that a yes?
That is correct.
All right. So
I take home about $2,000. Live off of that. That's tough.
your gross pay, according to your pretrial memo, is $6,000 a month, $5,800 a month?
I would say about $5,200 a month.
How much do you make annually right now?
$62,500.
Okay. And when you made over $100,000, you weren't making the gymnastic payments, correct?
I made $100,000, over $100,000 one time, and that was that year. So that isn't correct. I didn't always make that money. We've always made about the same amount of money.
I'm not going to go into the history. You were here for the trial. You understand that your tax returns and schedules for 2012, 2013, and 2014 were admitted into evidence in this case?
That is, yeah.
You're aware the court had Kroger's records as well as your health savings plan, correct?
Yes, yes.
I
I handed that over before you guys did whatever you had to do.
That's correct. And you recall there being testimony about stock options that were cashed out?
That is correct.
And there was testimony about a health benefit plan or a health insurance plan, which you had access to put money in?
Yes, and I was putting more money in there, but now I'm putting less money in there because I don't have the funds, again, to put any more money in there.
And I just want to knock this one out because it was mentioned in your pretrial memo. You pay for the kids' health insurance, correct?
Yes, for all the kids.
When you
yes.
say all kids, all three, your daughter Sierra is
That's correct.
22. So
That
she,
is correct.
let's say. And at the time of trial, you testified it was $25 each or $75 that you were paying for all three kids. Is it still the same, or $50 for the two kids that are minors?
It's probably more than that.
Okay.
But I don't have the numbers
Do you have
in front of me.
Do you have any evidence to support
I'm
that?
paying the insurance, if that's what you're asking.
Do you have any evidence to support how much you pay for those kids, that it's changed?
Yes, it's on my check stubs.
Okay. And that includes you and Sierra, however.
That
Do you
is
have a way
correct.
to apportion it out?
We can probably figure it out, yes.
If I were to tell you at trial it was $75, $25 per kid, Sierra being the oldest who's aged out, would you agree that's still around the same amount, $25 per kid?
Yes.
Okay. You were demoted on or about, what, February 2016?
I believe it was April.
April 2016? And you were demoted and you're still demoted to date?
That is correct.
Okay.
I got demoted because of store conditions.
You were supposed to, apparently, walk the store daily. Walk the store daily. That was something you were not doing. Is it something you're doing now?
I do that. I do that all the time. The problem is we were transitioning from having good quality to great quality, and then all the competition that was coming up, and the competition that I had around me, they wanted us to have the best product, and we failed to do that quick enough.
Well, there wasn't a transition in your job by, for instance, strike that. Your pay did not change for any other reason but for your performance, correct?
No, it changed because I got demoted.
And that was based solely on your performance, correct?
No, it involves others as well, and I mean, you're only as good as your people. So, yeah, it comes down to me because I was the store manager.
Okay. So what did you do, as you sit here today, to try and find or to get your performance up?
Oh well, we worked really hard as a team to try and get the store back where it needed to be, and my boss didn't think so, so I got demoted.
And why, since February or April 2016, have you not been walking the store and improved your performance such that you could make what you were making before?
Why what?
Strike that. I'm going to go back. According to the paperwork your attorney has provided the court, you were demoted for failing to walk the store and failing to hold meetings with your staff. Have you since improved those things?
Hold meetings with my staff. I improve it every single day. I don't know what I don't know what that hold meetings with my staff means, but what they mean by not walking the store, they mean that you're missing steps when you're walking the store. So that's what they mean. That's what it means.
In 2 years, 2.5 years, have you improved?
At this point, I'm pushing to get back.
Okay.
Yes.
And what physical limitations do you have to be able to perform like you used to during your marriage?
Well, it's all in my work, so it all depends on trying to get back up. I fought for my job, and unfortunately, I was still demoted, and so now I got a black mark, obviously, so I have to show my work again and start all over.
If for the years of 2012, 2013, and 2014, your bonuses ranged between $20,000 and $30,000, and now your bonuses are what, up to $3,000?
Yeah, my bonus potential is $7,500.
That's a part of the demotion too, correct?
That is part of my level of for an assistant.
What physical limitations do you have that you were unable to meet with your staff or walk the stores? What did you have at that time?
You mean in 2016?
Correct.
It was just that we didn't get it's not that I didn't meet with them, it's that I didn't hold them accountable quick enough. That's what it was.
Okay.
So it's not that I didn't meet with them.
Well, you were functioning well at the time of the trial, and there was testimony about your pay readily increasing over time and being well over $80,000, $90,000 for 5 years, the last 5 years of your 20-year marriage. So I'm asking you, what happened all of a sudden where you couldn't do your job anymore that you had been doing for 22 years?
Well, not only...
Objection, her question misstates the record.
You'll have an opportunity to cross-examine. Overruled.
Well, not only was I going through a hard divorce and, losing my family, which was tough, okay? So that kind of did not help. And then just my boss didn't think it was good enough.
Well, you're over it now, right?
I'm over it?
Yes, the hard divorce.
Get over it.
The hard divorce.
I got to get past. I got to go on with my life. Let's just say that.
All right. So, you must be under the care of a physician or doctor.
Why should I have to be?
Okay, is that a no? You are not?
No, that's incorrect.
So, you saying you've gone through a divorce, more than 50% of Americans have gone through divorce and still been able to function at their job. You're saying because of this divorce, you're unable to function at your job in your full capacity?
I said at the point in time, I was going through a rough time.
Okay. So, what do you have to evidence that rough time? Do you have any doctor's notes?
Do I need to have a doctor's note for
Yes.
that? Well, no, I don't have a doctor's note.
Did you have any physical limitations? Were you in a car accident?
No. But
All right.
what about the other 50%? Do I all go to doctors?
So let me ask you this. What did you do when your income dropped so rapidly to find or supplement that income?
Say that again?
What did you do when your income dropped halfway to supplement that income? You have kids you have to pay for.
That's correct.
What'd you do?
Got my wages garnished.
No, what
That's
did you
what
do
I
to
did.
supplement your income, to meet your obligations?
I continue to work for the company that I've been working for 25 years, so I can get back to where I need to be.
There's I don't know how
There's
many.
only so much time in a day.
How many stores are there in Las Vegas, Smith stores?
Probably over 40.
Okay, so did you make any request, job applications to any of those 40 other locations to see if you could get in a higher position?
Not yet, I have not.
Okay. Did you try and get an additional job, a second job, or something to supplement to make up so you could meet your financial obligations?
I have, but I haven't had time to do anything.
And you are, in your own words, this demotion is something that's permanent. You do not believe you can ever be back where you were before?
That is not up to me, but I put my best foot forward every single day.
And you've not asked for any increases in pay since April 2016?
We get evaluations every year, and my year came up, and I did not get a increase.
Did you request an increase?
I get evaluated by a number, 1 through 5. If you don't get a 3 and above, you don't get a wage increase.
Did you ask for an increase?
No, I did not ask for an increase.
Did you ask to stay the same so you didn't have to pay alimony or child support?
Why would I do that? That'd be silly.
So is that a no?
That's a no.
Did you apply for any job applications at any other grocery stores?
No, what I have done is applied to Lyft, and I haven't been able to work because I've been too busy. And
So are you a Lyft driver now?
I'm a Lyft driver, but I can't work. I haven't been working.
When did you start at Lyft?
I put the app in probably in May.
May 2018? Have you had any drives since?
I've made about $600.
Is there any reason this wasn't put on your financial disclosure form?
Because I haven't been able to work, so I just didn't. Oh, I see. Yeah, I guess I could have put it on there. I do apologize for that.
Do you
I
recall?
didn't think about it, to be honest with
Do
you.
you recall us having an issue with your prior financial disclosure form when you put you were paying $1,800 in alimony and $200 towards gymnastics of Ivy when in fact you hadn't done either?
Say that again.
I'll withdraw the question.
That was a mistake
I'll withdraw the question.
as far as writing a.
I don't believe I have any other questions, Sean.
Do you have a copy of the exhibit book, Ms. Bucci?
Yes, I do.
Do you have any objections to anything that we have in there? Because I want to offer and admit.
No,
Exhibits
to
A,
Exhibit
B,
A.
C, D, and E right now, Judge.
Okay. The only objection I have is to Exhibit C and D, as they don't include the required attached W-2s and the deduction schedule. So just for incomplete, but past that, no, Judge. No objection.
A and E.
No objection.
A, B, and E by stipulation?
A, B, and E, correct.
Okay, thank you.
Okay, A, B, and E by stipulation, the other two with those objections? Admitted or not admitted? I'm trying to find out.
Well, you can lay foundation. I mean, it doesn't.
A, B, and E are admitted by stipulation.
And then C and D admitted, but you have an objection? Is that what I'm hearing?
I'd like to hear the foundation. I don't think you can do it without the W-2.
Can you pay? Counsel went back and said that there was, specifically that there were tax returns that were admitted in your prior trial. They were saying that there was 12, 13, and 14. Did you go to Social Security and get a printout of what your wages have been?
Yes, I did.
Okay, in 2012, was it
Objection, relevancy beyond the scope of direct.
It's exactly within the scope. She brought up the tax returns.
Your Honor, the 2012 tax returns, 13, 14, with schedules were all admitted into evidence. I printed out my exhibit list in preparation for today. All the Kroger records, we had a lot of exhibits over 3 days of trial. What I don't want to do is recreate the wheel. I want to focus solely on his claim under 150 subsection 7, I'm presuming 11, for changed circumstances warranting future support. So I just don't see the relevancy in 2012, 2013, or 2014 that's admitted into evidence. Or judgments that nobody can touch anyways.
Your Honor, we're having testimony. We're actually testimony from counsel saying, why did you get money so you can get the double income like you did before? She keeps ignoring they made the same money. She keeps ignoring that in 2012, 13, and 14, he made $53,000, $56,000, and $54,000 already in the record.
Before
She's
bonuses,
trying
counsel.
to change the record now. Let's look over at the shiny ball. Maybe the judge will forget. But guess what? We can't forget.
I'm going to object.
That's
to
what
this
he was
argument.
making.
Your Honor,
Your Honor.
This is improper to redirect.
Am I going to be able to get out what his testimony is?
Well,
I'd
no, you don't
appreciate
get to.
if you would not yell, and I'd appreciate it if you wouldn't talk over each other. I'm not deaf, okay? So you don't need to yell.
And I'd ask
And I
that
can
she
only
doesn't
listen to
testify.
one person at a time.
We had testimony regarding 3 tax returns, specifically brought up, opened the door, kicked wide open by Ms. Frogie. I am following up. That's what I'm doing.
Go ahead.
Okay.
Overruled.
2012. I will show you this. What is this?
That's my income since I started
Where did you get this?
Social Security office.
Did you go there
Your Honor,
and
I've
get
never.
it?
I don't
Yes.
see what you're showing him. You need to show
Again,
me.
I'm not offering it for evidence.
Oh, Your
all,
Honor, even
okay?
then, whoa.
Stop. You're not refreshing his recollection.
Yes.
You're showing him a new document.
You can't do that.
That isn't an exhibit.
You can't do that.
So no.
Do you know what you made in 2012, 13, and 14?
No, I don't.
Okay. Was it $100,000?
No, it was not.
Was it
About
$50,000?
I averaged about 78,000, 74. So
Okay. So if I tell you from this document from Social Security, you made $53,273.01 in 2012. Would that be correct
that sounds right.
for you?
Yes.
Okay, so your combined income was about $100,000, but your income, meaning you, was about $53,000.
Yes.
Okay. The next year, 2013, $56,111.59. Did you make that income?
I'm
Yes,
just
I
going to
did.
make a continuing objection as to relevancy because it obviously
She
doesn't
said he
include
made
bonuses.
half. It was never the record. She's muddying the record. He has never made over 100,000. She keeps saying over 100,000.
I have a here in front of me, so I don't need anybody claiming that someone's muddying the records. I have in front of me order amending, order of May 26th, and final decree of divorce, filed October 2016. And at that time, I made findings as
Correct.
to his income, his base salary of $78,000. Bonuses. I averaged his 3 years of income because he
The
had
highest.
he had different levels of income.
We introduced 3
and
years.
it's
Right.
all in front of me.
And
So-
Your Honor, the tax returns that were admitted were the lower tax returns. And what I'm saying
Not
is, what
true.
you based your income on is the higher one, because the only one that is the high income is 2015,
I'm
and it's 118,500. That was 1 year, Judge.
And
That's
I-
why instead of having to pull backwards, we made sure go to Social Security. This is exactly what you've earned. Okay.
I'm not revisiting these findings of fact I made in 2016.
And I understand that.
You had
And we
a chance
didn't
to set
ask
it
for that.
aside.
But what I'm saying, what she's doing is saying, did you get something else? Did you do anything else? He is still with the company. He is still with the same company.
I heard that.
Okay.
It's it. I think
Okay.
they get it.
Okay. So now, let's be very clear. Did Miss Fuji take the 3 highest years that you made to do the income?
Objection.
Yes.
When there was a
relevancy.
trial in this matter.
Yes.
Okay, stop. I don't need you to argue what I decided in October
And I understand
2016.
that. And I understand that. I was just going over the stuff that she'd gone over.
averaged his last 3 years, 13, 14, and 15. I averaged that, and I averaged his bonuses. So I don't understand why we're making an argument that this information that was presented at trial may be incorrect. It seems if someone's muddying the waters, it might be you, Ms. Lozano, and I don't need that. I want you to make a record of why he has a change in circumstances. If he does, why he has a change in circumstances, that he's not willfully underemployed, and that he's entitled to the relief he is requesting.
Absolutely.
I don't need you to re-argue the trial.
Can you please look at what's in front of you, which is Exhibit A? We've had it admitted. Can you tell me what that is, please, sir?
That's the performance improvement plan that I got put on, the 30-day performance plan.
Okay. And who put you on this plan?
Sherry Wing, my district manager.
Can you explain the hierarchy on how it existed then versus now at a Smith store? How did it used to exist when you were, well, first of all, what was your position then?
I was a store director.
Okay, so what was the hierarchy from the store director from then down?
And then we had 1 or 2 assistants.
How many
But
assistants did
I
you
only
have?
had 1.
Okay.
And then we had department heads.
Okay, how many department heads?
About 6 department heads.
Okay. When it came to this particular review, tell me why the year before, which is 2015, okay, why you had your biggest year ever. Tell me what happened that year.
Because we hit a lot of our goals, and we hit it as a company as well. So
Did you ever make over $100,000 except for in 2015?
no, that was the only year that I made that much money. But then we ran into competitors, and we didn't do as well the following year.
Okay, explain to me the transition from 15 to 16 corporately for Smiths. What happened?
We had a lot of competition, and we had, like you were saying earlier, the Amazon coming through with the home deliveries and stuff, and we needed to bump up our game, and we have, where we, instead of going from good quality, like in produce, we went to great quality, so we couldn't even have things that wouldn't, keep for more than 2 days in a customer's refrigerator. So
Okay,
those
so
things
explain, let's
changed.
walk it slow. So, before in 2015, you're in good quality, and your people are doing good, and you said there was awards. Tell me about awards in 2015. How many awards did you win out of the 6 awards there?
Well, I did have like 4 out of the 6 awards, and but unfortunately I still got demoted.
Okay, but that was in 2015.
Yes.
When the corporate changeover happened in 16, tell me besides Amazon, who's your competition?
All Fresh and Easy, the remodels around the same store. Our store was one of the oldest stores.
Okay, explain what store were you at?
I was at Buffalo and Flamingo, and it used to be a Rayleigh's and never got remodeled. We had Trump and Jones. They had new facility. They redid it 2 different times. Flamingo Fort Apache. That was a newer store. Cleaner.
So hang on. So you're in the old store.
Yes.
With the good.
I'm going to object to leading. I'm going to object to leading because it's going there.
Sustained.
Tell me what store you're in compared to the other stores within a couple miles of you. Smith's. Just
Back
Smith's.
then?
Just Smith's, yeah. 2016.
How far or?
Conditions, why would people shop in yours versus the others? Just tell us.
Well, they would shop at the others because they have newer and cleaner facilities, and it's painted. I mean, it's good to the eye. Where I was working, it was older. Although we had the best customer service around there, they would like to go where they have more products. Just variety and whatnot, because we didn't have all the varieties that the customers wanted. So we were a lower volume store,
And that happened in 16.
Yes,
And is that when you were demoted from store manager to an assistant?
that is correct.
Okay, are you one of their assistants, or are there many assistants? How many assistants are there?
There are 2 assistants at my store right now. So we're supposed to get a third one, but they're going through their classes until they graduate. So then we'll get another one.
What do you mean? Do they have to go to a school, to a store?
Well, they have to take, I think, a 16-week course, and they look at, see if they, they went to college and stuff like that to make sure that they're qualified for the jobs.
So now, going forward in this new good versus great corporate structure, do they want people that are college people?
Well, absolutely. That's what they look for nowadays, to make sure that they went to college to see if they have any kind of degrees. So.
Did you go to college?
No, I did not. I made this my career, so I did not go to college.
And is this your intended career?
That is correct.
Do you intend to retire from Smith's?
That is correct.
Do you want to work for another company?
No, I do not.
So is it true when I hear that you made $118,000 that you made half of what was before? Was that a fluke?
Say that again? I'm sorry.
Was it unusual for you to make $118,000?
Absolutely. Yeah, absolutely.
Okay. Are you getting your wages garnished?
Yes.
Okay. When did the garnishment start?
I have so many dates, but I'm going to guess it was last year in May.
Do you know for a fact how much is taken out every check?
$1,647 throughout the month.
Okay. Can you,
And $23.50 bi-weekly.
okay, let's go to that. Let's look at your paycheck stub. And there's no objection to B, correct?
No objection
Okay.
to B.
Can you look at B?
Shows he's still married.
Can you look at it and can you see that this year, up until the pay period, which is
Because there's
July 2018, July 31st, that year to take, $11,529 has been garnished out of your check. Do you know if that's been garnished out of your check?
Where's that amount?
Yes.
Where, counsel?
Can
You're
you
looking
look at page 2, where it says 2 of 3, Ms. Virginia,
Yes.
this is 2 of 3, and then it says ACH Child Support 1.
Yes. Yes.
Okay, and then you also see fees are being taken out of it as well.
Yes.
Okay, so year to date would be $11,529. So that would be through July 2018, correct? July 31st.
31st.
Okay. And then also on top of that would be the $28, which would be the child support fee that's taken out. Is that correct?
That's correct.
Okay. And then you said before that health insurance was $25, but I believe you took us from your
Objection
stub.
leading.
Can you look on there and see what your health insurance is? You said before it could have been $25 at trial. But can you look on there?
The savings, $25.
No, that's for your health savings because you have to fund yours. But the one where it says for the children, the health 11.
It doesn't say for children, health 11. It just says health.
Okay, what's your plan for your
$4.90.
children?
What's that?
What's your plan for your children? Is it the health 11 plan for your company?
Objection leading.
I pay it as a whole, but it very well could be $4.90.
Okay. Can you look at your paycheck stuff and tell me what your health
Yeah.
insurance is coming out for you?
I'm sorry, I can't hear that.
Tell me what the health insurance is that's coming out of your paycheck for the children.
Asked and answered.
Overruled.
That means you can answer.
I mean, I can't tell what's for the kids and me, but it's, I mean, everything's on there. I mean, I paid as a whole.
Okay, do you
$490,
do you pay,
$350.
do you pay vision?
Yes, I do.
$13 a month for you and the children?
Yes.
Okay. Do you pay, and that's $13 a month, do you pay $35 a month for the children's health insurance?
Yeah.
Yes.
Do you put $25 a month into your own health insurance, a savings account so that you can go to the doctor?
Yes.
Do you have a vision plan for your injured children for $581?
I'm going to object. Every question is leading.
That is correct.
Every single question is leading.
And we're trying to get through the insurance, and he doesn't know. Judge, would we like to stay here all day?
No.
We're trying to get through the
What you
insurance.
say-
Document speaks for itself.
And I understand.
Absolutely. But we've asked him twice if he knows how much the children, and he said he doesn't. So you can't put words in his mouth. So my objection is leading.
And the floor. Sustained. Year to date.
I know it's year to date. He doesn't. They don't understand that.
Okay. Can you look at this document without me leading you?
Okay.
And can you please tell me what comes out for your children so that we can have it for the judge so she can properly calculate
It doesn't
what you're
say.
paying? She's supposed to pay half of it, so you're supposed to get it to us, so we need to go ahead and tell her that. So what is paid for you and what is paid for the children? It's separated out on here, but I can't
It's
lead you.
not,
I hear
and so
you.
I'm asking the court to admonish you not to lead him.
$490.
Sustained.
Okay. Can you, that says year to date.
Oh, sorry, $35.
Okay.
Let me see, 35, 13. That's
3513 and
and
581.
581.
Is that what it is?
Yes.
And Your Honor, I object to for the children. I believe the paycheck stub is for him and an adult child and the two other kids. So as I asked, it doesn't apportion out the two children separate from him.
Understood. Sir, are you married?
I saw that.
So the total that's coming out would be an adjustment you'd want from your financial disclosure form would be $53.81 a month, not $35 a month for what you get out for the children. Is that correct?
Objection,
Yes.
leading.
Sustained.
Can you tell me what you pay for your children? I do not want to tell you.
Your Honor,
and I don't
answer-
want to ask an
answer.
answer because we've had a sustain. I want to make sure it's in the record.
He said he didn't know. It's been asked twice.
If you look at your pay stub, could you tell? Did you sign up for these programs, sir?
Yes, I did.
Okay, so we
It's
just
a
need
yes
to know.
or no, or he doesn't know.
He said yes, he did.
No, he said he doesn't know how much is for his kids and him.
I believe that is his testimony.
Yeah, I don't know the breakdown. So I'll be honest with you. I don't know the breakdown of it. I just know that I pay it as a lump sum. So
Okay. But would you be asking the court to ask for a contribution for half pursuant to the statute so that mom would pay for
yes,
half? And you have to pay
absolutely,
half?
absolutely.
Okay, and
Thank
out of
you.
pockets as well?
Yeah.
And anything that you pay like that? Okay. Can you please go back to document 1A? Now, we want to understand how this happened. Okay. Can you explain how you went from making a great year to getting demoted by this letter? Did you agree with this letter?
No, I did not agree with this
What
letter.
did you do?
I fought it, and I just didn't agree with it. I even got my district manager even called me afterwards, wanting me to agree with her, and I told her that I could not agree with her because we were doing a lot of good things, and she felt otherwise. So, and I still, and I still got the demotion. So I did fight it though.
What were the biggest problems with your store changing from that good to great status, whatever you were talking about? What changed?
Well, what changed was going from good quality to just only having the best quality out, and making sure the store is like in tip-top shape, clean from from the corners to because of the competition. So
And what were your departments that did the worst in 2016 that basically helped you to get demoted? What were those departments?
Objection, relevancy?
We're trying to find out how this happened.
Well, it was.
Well, I can stop. When there's an objection, don't answer, okay?
Just wait till the judge.
It's not in this document.
Yes.
There's nothing about his departments. There's nothing about store competition. with
Amazon.
This is about his poor performance, and it says it's documented that he's continuing to fall below company standards. There's nothing in here about.
And that's what I'm asking about. Can you tell me what fell below company standards? Because you said it went from good to great.
Yes.
But what fell below the?
What fell below?
great mark?
What fell below was the standards in the quality of the produce, and then the service deli we had some opportunities as well, but for the rest of the store it wasn't bad. She just thought that not getting our first impressions to company standards would hurt our store, and she said that we were out of bed. So
tell me specifically about produce. What was not up to standards?
And once again, that's the quality. The quality going from good to great quality. And what I mean by that is, we were trained not to lose product. And
what does that mean? Trained not to lose product?
Trained not to
I'm
lose. To get it
way
through
beyond the scope of direct.
to get
Judge.
it through the check
object.
stand. To get it through the check stand, so we don't throw money away. Well, that had changed. That was changing to where you take it off the table, throw it away, even if it's good, and put the best out there.
Right,
So that was the change that we didn't get to fast enough.
So would that be the fall below company standards?
That's correct.
And what
how-
fall below company standards is counsel referring to or reading to her client?
Could you look at the letter that's in front of you?
I have the letter in front of me. What I don't have is anything about produce.
The key
It's 3
retailing,
pages.
the key retailing standards, that's
Okay,
in
Your
our
Honor,
back.
I move to strike that about the produce. This is not funny. Okay.
Your Honor-
I asked for Okay, good. For departments.
No, I'm going to
departments that
object to
work
your
underneath
testimony.
it.
I'm going to object to any testimony by Ms. Lozano, as she's not a grocery store expert.
And I'm trying to get it out of him, and she thinks it's funny.
No,
It's not funny.
You can't get it out by leading questions. There's a document. It's admitted into evidence. You can ask them about it, but you can't feed questions. And so my objection is beyond the scope of direct. Because I asked him the reason for his demotion, and he said because he was depressed about the divorce. Nothing about produce selection.
Was the only reason that you had a problem at the store was because of the divorce?
No.
Tell me the reason the demotion happened. She's trying to say
I
because of
said,
the divorce.
I said also, I was also going through the divorce.
Okay.
Okay, that's what I said
That was
to
a
him.
piece of it.
Yes.
Okay. But what was the main part of the problem that was at Smith's?
It was the store conditions, and that's what got me demoted.
So it was a changeover in company policy.
Yes.
Objection assumes facts not in evidence.
Sustained.
Look through this document. It says store standards are not being met, which includes but are not being not limited to not following the effective store manager. What does that mean?
And that's part of it. When you walk your departments, you walk the quality, you walk the freshness, you walk the cleanliness, and that's part of the effective store manager walk. So that's why when the issue came up, it was the produce department that kind of put was the last leg. So
Did you fire the produce manager?
no, I did not,
Why did you not fire the produce manager?
because he had other good qualities about him, and I did not hold him accountable quick enough. So
If you would have fired him, would it have been better for you?
Objection
so.
leading.
Second, key retailing standards. What is that?
key retailing standards is everything in its place in the back rooms and proper conditioning, meaning condition in the back, bring it to the front, fresh, and it's a lot. It's just everything in its place.
And did that change from 2015 to 2016 with this new corporate thing?
That didn't change, but there's always changes in it.
Okay,
So-
explain how it's been what, evolving?
Evolving,
Okay,
yes.
how's it been evolving?
Well, it evolves in many ways. It just it starts from the back door, you know, and when you receive the product,
Okay.
making sure that you properly receive it, making sure that it gets to the right place in the cooler, in the right spot for the product.
And are you graded on absolutely everything?
Yes.
Okay. Was that changed from before to now? Was that part of the changeover in the corporates, would you say, competition?
I'm going to,
It changes all the time. So yeah,
over?
it evolves. Yeah, they change things in it. Yes.
Okay, how are the standards evolving? Because I'm not an expert,
Okay.
and the judge needs to know.
Okay.
And if we don't get it out, there's
Okay.
no testimony.
Okay.
So can you please tell me how things have been changing without me telling you? So you have to tell me what changed in there that changed the criteria that got you demoted.
Well, what changed is that they wanted the great quality. They didn't get it quick enough.
They didn't want
But
it.
nowadays we only put out we only need to put out the fresh stuff. We still have things that are bad. And I'll give you an example. If you like,
I'm going
an
to
apple-
object, move to strike is non-responsive. I don't know if we need an example.
He's trying to tell us about the industry standards. He's very, very clear in pointing out that I'm not a grocery person. I don't know the industry standards.
Your Honor.
So I need someone who's in the industry for 25 years to show us how it's been evolving.
No,
and
Your Honor.
changing.
No, Your Honor. If in fact the store had changed and there had been a proof of criteria change, I'm assuming that would be something documented in evidence. In 20 years, if he was never demoted before, we've got a reason why. You look at it, you can't add a bunch of other stuff to it. I mean, that is what it is.
He wasn't store manager for 20 years. He was a bagger when he started.
Well, if
So, Your Honor, can I go through the document?
You can, but I'm making the observation that nothing that you're saying is in this
Yes.
document.
Can you go through? Shrink boards not updated and maintained. Was that something you had to do when you got your bonuses?
leading, objection leading, you can ask what it is, you can ask what it means, you can ask how it affects the demotion, but you can't lead.
Tell me what that
Okay,
means.
no leading.
And how it was different.
Okay, shrink boards. Those are I put up they're boards to show your loss, what you're selling, what you're not selling, what you're marking down, the process of where it goes to get it through the checkout to profit.
Okay.
That's the shrink boards.
And in 2015 and 2016, were they exactly the same or were they different? That's standard in the
good to me.
company.
Those were the same.
Okay.
Those were the same.
What? Just you look in the letter and you tell me what changed from 2015 to 2016 to earn you this demotion.
Well, just the,
That is leading
Yes.
also.
Objection.
There's nothing in this document that says store standards changed that led to his demotion. This document is replete
No, Your
with.
Honor. No, Your Honor. I'm talking about his testimony
Okay.
as to what
But
was
you
good
were-
versus a great quality.
You were asking him about this document. What in this document about store procedures has changed? Nothing in this document says that.
I understand that.
And you're leading.
And I understand that. Okay. This is what I want. What changed between 2015 and 2016 that they refer to in this letter? We can't talk about the company standards because we don't know about it. You must talk about the company standards.
And you can't coach your client while he's on the
Absolutely
stand.
not. Absolutely not.
But that's what you're doing.
Yeah.
So I need to know from 2015 to 2016 what changed.
If anything.
If anything,
If-
absolutely, absolutely
leading.
right.
You're
If
leading.
anything.
Because the competition is what changed,
And he's already testified to
and
that.
the competition is what changed.
Okay.
You know, and
Never competition before.
they were going from because the company it's always evolving. They want to stay ahead of the game, so that's what changes all the time. So for them to go, they work with They were doing customer service, in stock, meaning staying in stock. Even to this day, you know, it changes. So it has changed. But before, with the freshness, we used to not be able to lose that product that would be okay to buy today and tomorrow. Now they don't want it on the table, so that's the thing that changed. So when people take it home, they don't lose it. So then that way the customer comes back.
So what was
But-
acceptable in
so-
2015 was not acceptable in 2016?
Correct.
there things that you did in 2015 that were not acceptable in 2016 besides produce?
Your Honor, I just want to object because she's referring, it's a complete lack of foundation is what it is. It's a complete lack of foundation.
Sustained.
We can ask again. Tell me the difference in the corporate structure that you've been working at for 25 years, right? When did you start working there?
25 years ago next month.
Okay. What was the biggest change in the corporate structure in the time that you've been there?
Amazon and the home deliveries and, things
And what was
like
the year that happened? The calendar year?
2015, 2016.
We got it. It doesn't matter.
Okay. No, Your Honor, I'm trying to find out when we've already got the foundation in from an expert in the area as far as what he's doing.
No one's
Why
claiming.
is that not
Your
something
Honor-
that's changed? This is an industry standard from a store manager as to what changed, and you're saying
Again,
it's
this
not
is
acceptable.
testimony. Again, this is her trying to testify and argue while her client's on the stand. Your Honor,
Agree.
I'm
Agree.
telling you,
You're leading, you're coaching,
it is.
your witness.
It is. If she's going to say he got demoted because of Amazon, or he got demoted because of company changes, the question then is, where's the form that comes out every year? Where's the one for last year? Where's proof that the form changed from one year to another year? Where's proof of these standard changes documented? Nothing's documented. It's just words, and they lack foundation. So I thought this was something that could be done very quickly. All store managers across the board weren't demoted because of Amazon. So I don't understand the relevancy. What we should be talking about is what was the reason for the demotion. If that's all they've got, Judge, then I'm going to say it's repetitive and cumulative at this point. So I can get my client on and we can be finished.
What's your question, Ms. Lozano?
Thank you. I need to make sure that this court feels like we were in this thing happening, okay? And if they don't know everything in your head, then we won't be able to go forward and make a proper ruling.
Yeah, but you
okay?
can't
You
coach
can't
him.
even say
You're
that.
coaching
So I'm going to
him,
move
Ms.
to
Lozano.
strike the
I'm trying to
comments
make
by
sure we're going back
counsel.
on track.
You're coaching the witness.
Kimberly, please look at your document and look what's underlined.
What?
What is underlined?
Where? What page? They're bait stamped.
Page 1.
Exhibit A, page 1, Mr. Jimenez.
Yes,
Okay.
I saw it.
Okay.
Yes, this is something, can you tell me why it's initial? Why is it initial?
Because they're telling me that I need to make sure that I do my job, and if not, I can be terminated. And
As a result of this, have you been moved stores?
3 times.
Okay. Can you tell me what stores you were at the time of the divorce and where you're at subsequently and then now?
I was at Buffalo and Flamingo at the time of the divorce, then Green Valley Parkway and Pebble.
Okay, can you tell me why you moved?
Yes, I moved because we were not on good terms, because I was frustrated with this demotion. I didn't agree with it, and they felt otherwise, so there was a bit of a tension, and so they moved me to Nellis and Stewart.
Was it at the same pay?
Same pay as now, yes.
Okay. Have you, since the time of the divorce, 2000, it should have been actually May, and then you had the order entered to be October. Are you still making the same money, or are you making more?
No, I wish I was making the same money, but no.
No, I'm sorry. No, I'm sorry. Talking about when you got divorced, 2016. Okay, you said that's when the demotion happened, correct?
Right.
Okay.
2015, they were divorced.
Okay. It's 2016.
No, we were
Divorced in 2015.
no.
Oh,
2016. Okay.
So,
A decree.
so what's the question? I'm sorry.
Okay. At the time of divorce, how much was you making? At the time the divorce decree was entered, were you assistant manager? Or were you store manager? Which were you? Or was it in the interim time? I'm sorry. I know that there was a time for, preparation.
Entered, I think I was an assistant.
Okay.
Yeah.
Do you know when it happened, the demotion from store manager to assistant manager?
In April 2016.
So when you moved to Nellis, what happened?
So I moved to Nellis, and they were making moves, and then I moved to Pecos and Bonanza.
Why did they move you from Nellis to Pecos and Bonanza?
They were making changes with because they had new graduates that came through that graduated, new assistants. So they had to place them so they can get 3 in each store, and this store only got 2. So I ended up over here.
Did you have control over where you were moved the first time?
No, I did not.
Did you have control over where you moved the second time?
No, I did not.
Do you have control if they tell you right now you have to move to another store? Do you have control now?
No, I do not.
The other store managers around you, do they have college degrees or not?
I believe some, not all of them.
What about store managers now?
Not all of them. I thought you meant store directors. Assistants, I know they're looking for people that have been going to college or have a degree or credits. They're starting to bring people that are going to college in. They favor that. So
Was that what it was before, or is that
no,
different now?
not so much. Now it's like out in the open that's what they're looking for.
Do they actually put that in their recruitment documents or in their actual anything that they have that they want college graduates versus not college graduates?
I'm not sure. I'd have to look.
You've never seen that in writing from Smith's, have you?
No.
Can you please tell me on page, on your letter, there's 2 paragraphs at the end of the page. Can you read that last letter where it says you allow your associates?
You allow your associates to operate in the same way and do not hold them accountable for their responsibilities either.
When they talk about doing things the same way, why were they talking about doing things the same way?
Objection calls for speculation. How would she know why they were asking?
I can ask him if he knows about this letter. That's all. Okay. Was that when they're talking about how the old way versus the new corporate way?
And again, I'm objecting to
Yes.
they even speaking. That's hearsay, but it calls for speculation. I've never seen anything that they said that.
What portion of the exhibit are you referring to, Ms. Lozano?
The second paragraph from the bottom, Your Honor.
On page 1?
Yeah.
It starts out, these are just some of the issues that have already been addressed with you.
Correct.
Okay.
At the very last, it says you allow your associates to operate in the same way and do not hold them accountable for your responsibilities
Okay, thank you.
either.
Okay.
Okay. Is that what you were talking about with the produce manager?
Yes.
And also you said the snack deli manager?
Objection leading.
I'm refreshing the earlier testimony. I'm not leading him on anything. I'm not talking
I never
about
heard him
it.
say anything about any deli person.
Overruled.
The record will show differently.
It does. Overruled.
Yes.
It's just holding them accountable. That's not holding them accountable is what didn't help.
Okay, so does this show that their departments were deficient and you did not hold them accountable?
No, it doesn't show that they were. It just shows as an overall because I'm in charge of the entire store.
Does it also show that there was a change in policy and you weren't holding them accountable to it?
No, it doesn't show
What
that.
does this mean? Did you talk to her about this? You allow your associates to operate in the same way. What does that mean? What does that sentence mean?
That it wasn't. How would I say it? That I wasn't consistent. That's what that means. That it wasn't consistent. So the company standards weren't there every single day. The inconsistency is what it was.
So they're telling you new stuff, you're not sticking to it.
stocks. Yeah, I have that.
And this was a letter that was showing that if you didn't do things,
Objection leading.
Sustained.
what did this letter tell you?
Oh, asked and answered. Asked and answered 100 times. That's my objection, Judge. Asked and answered. The letter speaks for itself.
Sustained.
Can you go to page 2? Tell me what page 2 says.
Lupe, you have been warned multiple times concerning your performance. Despite these repeated attempts to help you improve your performance in a marked and consistent way, your performance continues to be deficient and unsustained.
And the areas you should discuss on that with was the snack deli and the produce. Was there any other areas?
Grocery at times, but more often produce.
I know you said your customer service was incredible.
Oh, yes.
Okay. Was anything else incredible?
Overtime, I mean, labor. I mean, there was a lot of good things. Just the conditions of the store weren't to company standards. And that's what got me demoted. And then not only that, we only have one assistant to the 2 and 3 that we have currently because it's a lot of work. Yeah.
So you had less people,
Less people.
more competition. How close were the other stores again? You said that you had
Objection,
your store here.
relevancy.
Sustained.
Okay.
Oh, we had about 4.
Don't answer.
When I
Don't answer.
sustain
She
an
said sustain.
That's
objection,
right.
you
You
don't.
did tell me that.
Yeah.
Sorry.
That's okay.
Let me get the rules stuff. Did you sign this?
Yes, I did.
Okay. What's a PIP program?
Personal improvement plan.
Did you do that?
Yes, and that was a 30-day, and then after 30 days, that's what I got demoted then. So,
Okay, so tell me what the PIP was that got you to the demotion.
well, the PIP was once again she came in, walked my store, and went through the produce, and the produce was it had quality issues. It did, and so she.
Hang on, were the quality issues acceptable in 2015, but not in 16?
Objection
No,
calls
it
for
was-
speculation. How's he going to know?
Don't know if he knows. So I'm asking the question.
I just don't know that it's relevant,
Me
Ms.
either.
Lozano.
I just don't know, was there a change? Was it,
There-
was
there
it the
has-
same
there
manager? Was
was-
it the same manager? Was
No.
Sherry the same district manager?
Yes, yes,
Okay.
she was the same manager.
Okay.
So
There's just no evidence of what you're pulling out through testimony. The produce in 2015, 2016, I mean, I can read this letter.
Yeah.
What it says. I don't understand your line of questioning. I'm confused.
You already said that you fought this demotion. Okay. And are you trying to get a job somewhere similar to where you could be a manager again sometime soon for Smith's?
yes, well, I'm trying to do that through my work. Yeah.
Can you go to this 15-week program that they're talking about?
I haven't looked into that, so
Do they want you to go to that first because you've already...
Leading. Objection leading.
Sustained.
not sure.
Sustained means
Oh.
that you don't answer.
Yeah. Do you have to do
So
anything
sorry.
to move up in the company? Do you?
Well, yes, I have to make sure that I'm performing excellent. Every day. I mean, I don't miss a day from work, even if I'm sick. I go to work. So, and I just have to show it through my work.
What will it take for you to get a higher paying job within the same company if you stay in that company?
Actually, a lot, because the job that I have now, it takes a lot to get everything done. And what I mean by that is reports and walks and security walks and whatnot. I mean, it's just a lot. But as long as I comply with that, I should be able to get up there.
And will we be able to get up to that same level of 2015?
Well, the only thing is it'll be difficult because of the competition. I mean, we have a lot more people now, a lot more assistance with, degrees, schooling. So I couldn't tell you. I just know that my experience would talk for itself. Other than that, then I don't know.
Did you want this demotion?
Absolutely not. I wish I would still be making the same money, but. So,
Would you do anything to make less money to pay less child support?
no,
Would you
No.
do anything to make less money to pay less spousal support?
no.
You gave us. Can you look at page 3? I mean, page Exhibit C. Can you tell me what it is? In 2016, did you have any other income besides?
Are you
this?
withdrawing the question?
No, can you look at this?
Well, you have to refer, it's not in evidence yet.
I
so
understand. Can you just look at this?
I think you want him to recognize the document. Do you recognize that document?
2016.
In 2016, I just want to make sure because it was a statement that you made earlier that I want to make sure the record's clear.
Okay.
Okay. In 2016, did you have any other job?
I don't think so.
Okay. So, and you said 2018
I don't think
was
so.
the first time you talked about Lyft, correct?
Yes.
Okay. So I'm just talking about 2016 on this one. Did you make $84,619?
Yes.
Okay. Did you have any
I'm
other
gonna-
source of income? Because I don't
I'm
see
going
any.
to, listen, I have to object to the leading question because he never gave an amount. This is not admitted into evidence, nor was it prepared by him, so it lacks foundation, nor is it complete, so I can object to the best evidence rule. So if you want to ask him what your understanding of what you made, and that refreshes recollection, it's fine, but I have an issue with you saying, did you make $84,000?
That's
you
not
know.
where it was going. I
Is
just
that
wanted to
what
make sure
your
there wasn't any other
accountant
income because you brought up
reported?
the Lyft income. I wanted to make sure it was clear. That's
Right.
all.
You're
All right.
leading the witness.
Yeah.
He can't testify from a document that's not in evidence, and you were not using it to refresh his recollection, so the objection is sustained.
Do you know what you made in 2016?
84,000.
You can't testify from the document, so
Oh,
it's not in
323.
evidence.
84,000.
Okay.
The testimony is stricken.
Thank you.
So we don't look at this then?
It's not in evidence yet,
Oh,
so
okay.
you can't look at it and testify from it.
Do you know if you filed income taxes in 2016?
Yes.
Okay. Can you look at this document to see if this is an incomplete copy of your tax return?
I'd ask additional voir dire. If I could quickly voir dire him on this,
I
Your
just want to
Honor.
make sure that this is the income.
And I would, if I could ask, Lupe, did you prepare your own taxes in 2016?
No.
Did you provide your W-2 to your accountant in order to prepare it? Don't look at your attorney.
Am I supposed to answer it? I mean, I don't know. I just want to make sure. I just,
Yes, she can ask you these questions.
If you could look at
That's my
me
paper, yeah.
and not look at them, you did not prepare your tax return for 2016, correct?
no.
You did not prepare it for 2017, correct?
Correct.
And you gave your accountant your W-2s. You have to, right, to prepare it? Okay. Is there any reason why you wouldn't give them your W-2? They'd have to have your W-2, right?
Yes.
Okay. I have no other questions.
Do you have an objection to the
Yes, I do, Your Honor. It
Well,
doesn't
she
include
hasn't
his-
asked to admit it.
Yeah.
but-
Yes, Your Honor. I would ask to admit it for the limited purpose of the one thing, which
Your Honor.
is, again, because I wanted to make sure that there wasn't another income that was in that year, okay? Because he did talk about the Lyft income this year, okay? So I want to make sure that it was very clear for calculation purposes what he made in 2016.
And I'm going to object to the form of the word, what he made. A lot of times
What he
people
earned.
report differently without his W-2s, which is really what we need, so you can see how much is contributed to a 401k, health savings, plan and the sorts, I would say it's incomplete. And it doesn't
And I would
have the
say it
schedules.
accurately reflects the wages and the salaries that are normally kept by the IRS, ordinary business expense. I mean,
His testimony is good enough. I object to the document being admitted as incomplete.
and Your Honor, if I can as well, I can tell him that he had one. She went ahead and did this. Did you give him one document to prepare this?
Yes.
Regarding your income. So would he have made up the wage on line 7 for wage and salaries?
No.
Okay, so it would have been information you gave to him?
Yes.
Okay, is it the same person that's been doing your taxes for how long?
4 years, 3 years, 4 years.
Again, Your Honor, I would ask that he be able to testify just to his income.
The question would be, then why is it not included in all the schedules? The question would then be, why is your 1099s, which is another source of income, and your W-2s not included? And if he doesn't
Did
know.
you have any
1099.
1099s? So did you have one document which would be your W-2?
W-2s, that's it.
And that's all you had?
That's it.
And do you know any reason why it's not included?
I do not know.
Then my objection is just for the admissibility of the document itself, but his testimony can be whatever it
Again,
is.
I'd like him to testify as to his wages and income on that. That's what the purpose of this for, Your Honor. And he's already testified he didn't give any other wages or anything else to them.
All right, it's admitted.
Thank you. In 2016, how much did you make?
$84,577.
Thank you. Same thing as to 2017. How much did you make?
Hold on. Is he referring to a document, or are you just asking him for his recollection? You can't testify from a document
Correct.
that's not in evidence.
I don't even think to
Okay.
say.
I'm sorry, Your Honor. I thought you said admitted as to that limited purpose onto the two as far as income.
We went on to the next year.
Okay. So I was just trying to do them both. That was it.
Well, we haven't talked about D.
Okay. Do we have the same objections as to D?
Yes.
Same thing, Your Honor. I'm using it to show the actual income that he had.
I think you need to lay the foundation,
Okay.
as you did for 2016.
You got it. Can you see D?
You can't look at it. You have to. No, I'm going to object to
Can
looking
you
at it.
tell me in 2018, did you have your 2017 documents, a W-2 given to an accountant for
Yes.
taxes?
Yes.
Is the same person you've been using for 4 years?
Yes.
Okay. What document did you give them for the?
W-2s. That's it.
Well, then he can't definitely look at it because it's not included.
It's the same thing that we did before. Did you give them one document regarding your income?
Yes.
Was there any other document regarding
No.
income? So this one on line 7
No.
would be your only income that you gave to your accountant.
Yes.
Is that
Ask
correct?
him how much he made.
Yes.
Okay. Now I ask that it be admitted, Your
It's the
Honor.
same objection. If you want to ask him how much he made,
I
and he
want it to be
doesn't,
admitted, Your Honor.
if you want to ask him how much he made and he doesn't know, and you want to use it to refresh his recollection, that's fine. But the way you're doing it is not proper. You want to throw a number that's not accurate. So
I take note of your objection that the document is incomplete, and that goes as to the weight of the evidence, but he's identified this as his tax return. So
Sorry.
it's admitted,
Okay.
but as to the weight, I understand your objection that the backup documentation is not provided.
thank you.
In 2017, can you tell me what your income was?
Now you can look at it, sir.
You can look at it now.
Admitted.
$84,322.
Hang on, you're on page
Oh,
it's
hold on.
D. It was,
Oh.
If you look at the bottom, look at GM 19. See those date stamps for lawyers? 19.
$62,582.
Okay. Can you tell me what the difference between the two? Why you had 84, 619, and 62,582? The difference between the two. Why?
Because I make less now. I went through a demotion and I make less money now. I'm an assistant and that's the wages I make, 62.5. And bonus potential was 7,000, and I only received about 3,800.
And can you tell me what the bonus potential was when you were a store manager versus a store assistant manager?
Bonus potential was 20,000
For?
for a store manager.
Okay.
The year that I made 35 was because they had an inflator, which at the end of the year, which that means that the company was doing well, so they added like a customer service piece. So
What's an inflator?
an inflator is like say, oh, like they give you another goal on top of the goals you have, and if you hit that goal, your mark, then it goes over 100%. But that was just that 1 year.
Did you have inflators the years before?
They've had them before, but they don't always have them.
Did you ever get an inflator that got you this kind of bonus?
No, that was the first one. That's why I made 35,000, because it inflated from 100% to 176%, because that's how good we did that year.
Is that because of customer service?
Yes.
And can you look at E, please? Your Honor, for the records, I'm hearing C and D are admitted, but with the objections noted. Okay. Can you tell me what that was? E?
Yes, that is cashier's, the bonus that the other half of the bonus that I got to you to give to Valerie, to give to Angela for the other part of the bonus that she didn't receive, that was sent to me, was given to me, but I borrowed it from my family and gave it to her immediately. I wasn't sure what had happened to the other part, which it seems like it got lost somewhere.
Did you then go to Smith's and find out what happened to was an order ever given to Smith's?
Right away, I went and I made phone calls, and as far as I know, that they said that it was sent out, and then so I don't know from there what happened, because I believe you took over and you called after I gave you this check, because I told you that I had called 3 times, and when I went to call, they said that they already had given her part, so that's why I thought that part was mine.
And did they explain to you that they never got an order from the Squeegee's office?
No, they did not.
Well, then how did I get all the, there's like 5 orders in here.
They couldn't find one. That's why they were all shocked.
I don't understand your answer.
Okay.
The question was, did they explain to you? And you said no, they did not. So
What do you
is
mean?
it that they didn't explain to you, or they didn't get the order? I don't understand your
No,
answer.
they said
the way
that,
the question was
no,
worded.
they said they sent her part when I called on it, because when I got when I got the check, I asked about it, and they said that she got her part. So I thought that was my money. So I spent it. So when I came to court, I thought, that it was my money. So then I was supposed to give it to her, and I already had spent it. So my family put money together, and I took it straight to Don's office right after we left.
I understood all that testimony, but the last question was, did they explain to
No,
you?
they didn't explain. They just said that she received the money.
So they didn't explain anything to you?
No.
Okay.
So when you heard the words, and I'll quote back to you, she got her part.
Mm-hmm.
Did you think you were following the court's orders?
Yes,
Okay.
Did you understand her part is 100%?
I do now.
Did you-
I do now.
It's in the order.
Yes, I know. I know. There's a lot, and yes.
Is there a lot in this legal stuff that's been a little puzzling for you?
Yes.
Okay, what's been confusing for you?
Objection, relevancy, beyond the scope. We're not going to sit here and talk about what's been confusing with him. He's been represented by counsel all along, except
He
for the
has not
trial.
been represented
Okay. I
by
agree.
counsel all along, and that's been the problem.
But
No,
I do
that's-
believe it's way beyond.
At the time of trial, he was represented by counsel, and I asked him a specific question. Did he understand that she was to receive 100% of the bonus? And he said he did not.
And just so you know, they did a poor job because I was given documents out to them to have here, and they weren't even turning them in. So
Are you talking about prior counsel?
So that's in my defense. I don't know. I mean, but there is a lot that I'm unknown with, so I do apologize.
Did you understand that you should have gotten an order to your payroll department?
Objection, leading.
That I should have?
Yeah.
Sustained.
No.
When you said you're confused about the law part, did you represent yourself at trial?
Yes.
Did you understand there was a lot of stuff that you were supposed to do that you did not do?
Oh, yes.
Your Honor, I'm not sure how are we going, because I've gone off of mainly most of the testimony that she's talked about. Should we stop and then have my first case go forward with him afterwards, or should I continue this way? I'm not, because we asked that we took him as a hostile witness because we took him out of order. So, do you want me to, can I continue with him after she's put on her case? 'Cause she's
I would love to
nurse?
finish it, but I don't know. We have a half a day. I
Uh-huh.
don't know how much more we have. My
Okay.
questions are very limited.
Because I'd like her to be able to put on her witness and then go ahead and.
I don't even know if I need my witness. I just need to follow up my questions, but if there's additional testimony, I don't know what it's about.
Do you want her to go outside the scope?
Yes, if she needs to.
I was just wondering because of where we were at, Your Honor.
I
by
just want some
stipulation,
offer
you
of
can
proof, Judge, because I don't want to spend, and I knew it would be very long for their side. I wrote out my questions for my client. It'll be a quick 10-minute jobber, but we should be entitled to the equal opportunity. I just don't want a fishing expedition.
And that's why I
to go
said
long.
she can do it right now. So I said,
No,
think it's
I
a good
don't want
idea.
him called again. Would like her to finish.
All right. She has completed her direct.
Mm-hmm.
She has agreed that you can go outside the scope.
I would like to only call my client after her client at this point, Your Honor. Absolutely.
Well, you don't
So-
get a rebuttal witness. This is it.
Yeah, I can rebut what he has to say. Absolutely, I do.
Well, yeah.
Absolutely, I do.
So are you finished? Are you finished with your cross-examination?
Well, I mean, I'm trying to figure out how we're doing it because it is a cross, really, of a witness that she took as a hostile witness.
Right. And she's agreed you can go outside the scope,
Yes.
but you don't have to.
Okay.
So if you are finished with your cross-examination, he can step down.
And I'll ask my
Let's do that.
follow-up
Yeah, and then we'll
questions.
just do yours on direct, so I have to ask the questions
All right, no,
backwards. whoever's
you
doing.
still need to stay, Lupe. I was going to follow up. Lupe, do you have any evidence or any documents other than what your attorney has introduced into evidence showing that somehow Smith had changed some of their, the way they do their assessments of people?
I can look into that. I don't know of it. but-
Would it surprise you there's been no documents listed that show that?
No, there's got to be something.
Well, you're going to offer to it today. I'm saying you
Oh,
have no
I don't
evidence.
have anything to offer today
Okay.
as far as that.
All right.
is.
And is it true in over 20 years, the 22 years, you have never been demoted before, correct?
That's correct.
This criteria change, you have no documentation to support that, correct?
I do have documentation.
To provide today?
Well, you guys have the demotion letter.
The demotion letter does not say that their criteria
They
changed.
put me on a 30-day. I turned that in. They gave me a demotion letter, and it says that I was demoted. What
So you-
else would you like?
Do you believe that is proof that the criteria for Kroger and Smiths had changed?
No, it's proof that I got demoted.
Yes. Do you have no evidence or proof that the form that they used for the demotion has changed, correct?
The form, no.
Okay. And you say you get these every year. Is there any reason why you only gave us 2016 and didn't give us 2017 or 2018?
Gave you 2016 what?
The demotion letter. You said you get reviewed every year, correct?
It's evaluation.
Is there any reason you didn't provide your annual evaluation after this demotion in April 2016?
Objection relevant.
You didn't ask for one.
Well,
No one asked for anything, so
Okay.
no, there's no reason.
That letter says, Exhibit B, that it was a temporary and that you had 30 days. Is that correct? What happened after the 30 days? You were demoted?
After 30 days, I didn't get demoted right after 30 days. It was a 30-day improvement plan, and then in April, I got demoted.
And is there any reason why the improvement plan was not included in these documentation?
Well, isn't that the letter that says on there the key retailing, the shrink boards, not following effective store walk?
So this is the improvement letter?
Yes.
Okay. There's no documentation, is there, that Smith's or Kroger managers require degrees, is there?
I don't know that there is, but I know that that's what they're looking for.
Okay. You have no documentation today that evidence they require store managers to hold degrees? Okay. Now, this store you said that was doing so poorly, this is the same store you received, that you got demoted at, was the same store you received a $36,000 bonus, correct?
That is correct.
All right.
Objection. I
30,
believe is third.
35,000.
Isn't true you still have stock options, correct?
No, I do not.
Did you provide any proof that you no longer have stock options?
Did you ask for any?
That is not a question. You don't get to ask me questions,
Well,
unfortunately.
I
I get to
didn't
ask
bring
you.
any because I don't have any, so I don't have to show that I have anything.
So what did you do with your stock options you've always had?
Well, I didn't get it. When you get evaluated, they give you stock options by whether you do your performance. And now they also changed it where the assistants don't get a stock options.
So as you sit here today, you're saying you hold no stock with the Merrill Lynch account?
Correct.
You still have 401k?
Yes.
I believe last court, your 401k was in excess of $40,000?
Yes.
Why can't you use those funds to make your support obligations?
Because I have a loan out and I can't borrow from that.
Where's the loan?
Well, the loan was before we were together when we got the loan
Where's the loan from?
from 401k. And I was only allowed to borrow. I only borrowed like $2,200, and I'm paying. And we've been paying it real slow, like $25 a month. It's on there. It's on the.
It's on document 007.
Oh, no, it's okay. I've subpoenaed the whole file from Kroger. I have the whole thing. So it's your testimony today you no longer receive stock options?
No.
Do you still have stock with
No.
them? What did you do with the stock?
Well, remember I used the stock to live off of back in 2016.
You cashed out any and all stock that you had? Is that your testimony?
Yes, you know that.
And you have no other stock holdings?
No, I do not.
Okay. The divorce in this matter was filed in 2014.
16.
The divorce in this matter, the complaint was filed in 2014. You did not get demoted by your own testimony until April 2016. This letter was drafted in February 2016. Other than what you've explained, when we read in the letter, it says, Goal 1, effective store walks are completed daily. You weren't doing those. You
Are
have,
you telling me, or are you asking?
that's what it says, so the document speaks for itself.
Okay.
And you're telling me the reason the effective store walks weren't completed daily was because of Amazon and because you were depressed?
Objection, misstates the testimony.
Were there any physical limitations on
Your Honor, objection.
I don't recall his testimony about the effective store walks being linked to anything.
Okay. All right. Then I'll withdraw the
But it's
question.
cross-examination. Technically it's direct, but he's a hostile witness, so.
I'll withdraw the question, Your Honor. If it's not tied, it's not tied. After 30 days on this demotion letter, did you get a subsequent letter evidencing your demotion?
No, I got demoted in April.
Can I ask a question?
Yes.
Is there a reason why you didn't improve your performance after being warned that it could result in possible separation from employment?
What do you mean, like during when we were coming to court?
No, this letter is dated February 22, 2016, and you're being warned. And it says in here that you've been warned before. Okay, you have a track record of being warned. And you were demoted 2 months later.
Right.
Is there a reason that you didn't meet expectations, so they went ahead and demoted you?
No, we actually.
After you'd been warned.
We worked hard to get the store to where it needed to be, and still she came in and because when I had a conversation with my boss, she said that I wasn't going to make it. She told me before I even start.
The expectations of you were that you do the store walks. Did you improve that?
Yes.
And did you improve the product being outdated?
Yes.
Did you improve the shrink boards being updated?
Yes.
And so you did all of the things that they asked you to do in this performance goal plan? This performance improvement
The
plan?
produce still had quality issues, is what put the end to that, because we did better and it looked better and the store was cleaner and all that, but the produce still had quality issues. And by that means they pulled out product. They went through all the product and see if there was bad quality in it. And of course they found some. You're going to find that in any produce. So yes, there was quality issues in there. So that's why I didn't.
Is there a follow-up letter to this performance improvement plan that you failed to meet this plan?
There should be another letter in there that says that you were demoted.
I saw that.
What?
But my question is, did you get another letter saying you have failed to meet these 4 goals that we have given you?
Well, no, there's a letter that says that you are demoted. This one is saying.
I understand that.
Did you see that? There's 2 letters, right?
Was there a letter after this February 22nd performance improvement plan
There is.
that told you did not meet these goals?
There is. It should be on file somewhere in there. There is.
Okay.
It's
So it's
in
case
April.
005?
Oh,
You're talking
there it
about
is. There's the letter right there, right after.
05 in Exhibit A?
Yeah.
Those are the only things we found, Your Honor.
Yeah, it's the one that's, yeah, that's the one.
And it
It
says,
says 4/22/16.
okay, so you were placed on the performance improvement plan to address your work performance issues. And they said you had not met the objectives. And some of the areas were store standards not being met daily, not following the effective store manager walk or following up on tasks assigned to you, and store not to key retailing standards including backroom conditions, out of codes, and cleanliness. So those are the
Yeah,
reasons.
and they did, they did have out of codes in the in the grocery department. So those two things,
I have a couple.
Yep.
Thank you. You said you had no stock after 2016. If I were to indicate to you, you cashed out stock as of July 30th, 2016 for $7,378.71, and we're still receiving stock dividends at that time. Would that be a lie?
How much was it?
$7,378.71.
And that we talked about. That's the 10,000, and then they take the taxes out. It's 2017. It was in 2016.
And that was July 2016.
Yeah, that's the one.
So let me get this straight. So after this demotion, you still had stock, but you cashed it out.
Used it to, yes, to live off of.
And when you had that money, you still hadn't paid any of the outstanding orders at that time, correct?
Any?
Correct.
July.
I'll withdraw the question. In 2012, you were making $71,365. That's 2012. You had only gone up every year ever since. Now, all of a sudden, none of this paperwork...
Objection, Your Honor. That Ms. Stacy's
my-
testimony earlier.
I can show it to him, but if I can get my
Ms.
question...
Stacy's testimony where he said that he made $53,000 in 2012. That's Ms. Stacy's earlier testimony.
Your Honor, if I may approach refresh the witnesses and use for impeachment purposes.
Yes.
I'm going to show you a document from Kroger that I received via subpoena duces tecum, 3 of which I submitted on Kroger.
Your Honor, this is not a W-2, so
That's fine. You're
this
gonna
is just a
check-
pay range, and I have his actual from his Social Security. So that's a pay range document. That is not a W-2.
It's not. I'm showing you a document from Kroger Company on their letterhead that says the pay range, minimum 70, maximum 91,500, but then it lists at the bottom your current base pay of $71,365.08. Do you disagree that at the time in 2012, your base pay, absent bonuses, was $71,365.08?
Objection. Misstates her own recollection of the testimony from trial, as well as the trial exhibits that we already have on record, as well as the Social Security statement that we have.
Trying to lay a foundation.
And his earlier testimony.
I'm trying to lay a foundation. I just wish you'd make an objection.
Objection. Doesn't represent his income.
You don't dispute that Kroger gave this document and list your base pay. Do you recall what your base pay was?
Objection does not say his base pay is that. It is not a W-2.
You looked at this, right?
Yes, it is not a W-2, Your Honor.
I understand that. I understand it's not a W-2. She's stating it was a Kroger document stating what his base pay was.
For 2012. And it's a foundational question if I could get it
And
out.
corrected, it shows a range of pay. It's not hers.
Please, let me
Again,
get my...
just like you had a problem with not having
I'm not
the
trying to
document attached
introduce-
to a U.S. Filed tax return, I have a problem with it not being an actual document.
Well, she'd probably have a big problem if I introduced all of Kroger, which I have forced.
Which should have been done before trial. We've had none of this done.
Judge,
She's
Your
using
Honor.
this for impeachment
And any
purposes.
exhibits, again, should have been done.
You got it too. You're on my subpoena.
Right here.
And there's a reason it's not in.
Okay.
Judge,
Proceed, Ms.
Thank
Fuji.
And Your Honor, we've gotten none of these documents that she subpoenaed, which she's required to give me a copy. We opened discovery. I got none of them. Zero.
If I can get my question out, Judge, I'll withdraw the question. If your base salary, according to Kroger Company, if I can finish the question, in 2012 was $71,365 without bonus, and it continued to increase every single year, how come these documents in Exhibit A don't show what your salary was demoted to?
Objection to any of the documents that she did not produce to us. We had discovery open.
She's not using it.
I'm not using it. She's got a...
Objection misstates his
I would
earlier
like him
testimony
to
as to
answer-
what his income was.
It's a pretty easy question.
Overruled.
Don't look at your attorney to answer your question.
Well,
okay?
I need to know whether I can answer. I don't,
Can
I-
answer.
Yes, you
You
can
need
answer.
everybody.
Well, it shows on the Exhibit A on the last page where I'm getting paid $62,500.
And did you choose that amount yourself?
Absolutely not.
Is
Why would
that,
I wouldn't
is
do
there
that.
any reason why you didn't present evidence that showed that was a salary that they chose for you, not one you chose for yourself? And what document are you pointing to that shows your salary in Exhibit A?
Go to page 4. It says salary would be 62.
$2,500. This is not proof that you were demoted. It was an offer you accepted.
No. I was demoted. I did not. This is not an offer. This is either you're going to do this or you're going to not have a job.
Well, it says you were eligible for a pay review on GJ0004, a pay review. Did you get that pay review?
No.
Is there any reason we don't have a copy of that pay review or subsequent pay reviews?
No.
I have no other questions, Jonas.
Miss Fuji was worried. She said the sentence, this is an income you chose for yourself. Are you able to set a salary for yourself at the Smith Corporation?
Not at all.
Did some of the problems with your new standards have to do with you being in a remodeled old Rayleigh's?
Objection calls for leading,
Yes.
leading,
Sustained.
and calls for speculation.
Sustained.
Okay, within 3 miles of where your store is, when you were being demoted,
This is going to be leading.
Yes, it's sustained, and we've already had this.
I understand.
These questions have already been
I understand.
proffered, and he's
Were
already
you
testified.
given the stock options in the divorce?
Was I given?
I just
No.
read the decree. Were you given the stock options in the divorce?
I don't know. I don't know.
Okay, if I can read to you what the judge said that you were given the stock options, would you believe what the judge said that you were given the stock options in the divorce?
No.
Hang on a second.
I'm going to object to relevancy.
I'm wondering why we're going on about stock options when it was already talked about. It's already been done. Let's muddy up the waters more. Again, in page 13, line 8 and 9, it says stock received and liquidated by the husband. 14, 15, and 16, right in the decree. Why are we talking about stock options? Other than he got money.
Is
It's
that
already been litigated,
is
Your
that a
Honor.
question or
Anything
an
regarding
objection?
stock options, I ask to be stricken. It's already been litigated.
She should ask.
Your Honor, I ask that that be stricken.
I don't
It's
know. If
not
I,
additional funds that we're looking at.
I don't know if I need to
I think her point
respond.
that she was trying to make was that did he have additional
Correct.
funds available
Sources.
to him, and he said that he did not.
Did you understand that stock options were dealt with in the decree? That order I just read to you from the
That
judge.
you did not.
No.
Okay. When you got the stock options, was that part of the stuff that you thought you were taking away from her or you were living on?
I was living on.
Okay.
It's part of the equalization.
Because the thing is, I was paying her as much as I can, and after the 4th month, when I was paying the alimony, I ran out of money. I had no more money.
So how many months did you pay the child support and alimony?
I'm going to
Alimony
object.
4 months and child support.
Hold on. When there's an objection, stop talking.
Okay.
It just has to relevancy at the time. All this was already discussed, and we have schedule of arrears. I don't know what the relevancy is. He
Other
said he
than the
couldn't
fact that
pay.
she says he's paid nothing. Nothing is not nothing if it's paid. And I cannot have you ever thinking, Judge, that he paid nothing. He paid as much as he could until he couldn't pay
Your Honor,
anymore.
And I know that neither one of you have asked him about these schedules of arrearages, but I would like that to happen before we conclude.
Yes, Your Honor.
I think you have a duty, Ms. Lozano, because they're under oath,
Correct.
filed by the plaintiff.
Correct.
So there is a presumption that they're correct because she filed them under oath, so you need to address those things with him. There are 3 different schedules: the equalization, alimony, and gymnastics. I don't think there is another one for child support. I think it's just those 3. We're going to take a 5-minute break.
Okay.
Thanks, guys.